versus Nicholas Ninow, case number CC30 of 2019.
As the court pleases, my lord, I confirm my appearance for the state.
Yes, sir.
May it please my lord, I still appear on behalf of the
Thank you,
accused.
Mr. Alden. Where is the witness?
I see she's sitting in court. I apologize, my lord.
Excuse me, can you come forward? I want to remind you that you are still under oath. Yes, Mr. Lawyer.
As the court pleases, my lord. Ma'am. Good morning. Ma'am, yesterday, before we adjourned, you said you apologize on behalf of your grandson. And you mentioned that you also want to apologize to the family and you would want to talk to them.
That's correct.
And when do you intend to talk to them?
I have no idea. I would like to be given the opportunity.
And did you make any arrangements or?
I don't even know who they are, and I don't know how to contact them. It's been on my heart since the night of the incident. And I was also afraid it might be inappropriate.
And you know who's the investigating officer in this case, is that not so?
I do, yes.
And after the incident, have you ever spoken to the investigating officer?
I have, yes.
Have you ever tried maybe to find out from him whether how you would, if you want to talk to them, how would you go about?
I have not. And the reason for that is because I don't trust the investigating officer.
You don't do what?
I don't trust him.
You don't trust him?
No.
Why?
Because on several occasions he tried to get interviews with me and told me he'd spoken to my lawyer and my lawyer had given permission. And when I contacted my lawyer said I have not spoken to Mr. Botha. And so I became afraid of him.
And have you maybe spoken to your lawyer to find out as to how would you go about if you want to talk to the family?
No, ma'am, I haven't. But I can tell you, my heart is with that mother, and my heart is with that father and with that child, and it always has been. And I was not sure if it was the appropriate thing to do, but it has been on my heart that I will make every opportunity to be able to talk to them if they will allow me.
Ma'am, when did you decide that you would want to talk to the family and apologize?
Right at the beginning when everything happened, when my son was arrested, my grandson was arrested.
And it is 13 months now since the incident.
I repeat, I have no knowledge of the law, and I was not sure that it would be the appropriate thing to do.
Ma'am, I'm going to ask you a question.
Yes.
And I will request you not to give the name of the place where I'm going to ask, the question that I'm going to ask you. Is that
That's
okay?
good.
Do you perhaps know where this family stay?
Which family?
My lord?
Which family are you referring to?
The family that she wants to apologize,
Okay,
the family of the victim, yes.
No, I don't.
Again, I'm going to ask you, please don't mention names or places.
I understand.
Do you know maybe the surname or their names of the victim and the family?
I know the little girl's name, yes.
Only the little girl's name.
Yes.
Ma'am, it is inconceivable that today or since yesterday, now that you are pleading for your grandson's mercy in sentence, you come up with a statement to say you apologize and you will want to talk to the family and, you know, show empathy with them, but you've never contacted anybody, never made any endeavors to try to find a way to talk to them. I put it to you that it's something that you come up with now only to show the court so that your grandson can get mercy on that.
With all due respect, ma'am, I don't see how my grandson can get mercy because I would like to talk to the parents and to the child. I don't see. That is a personal thing between me and the parents and the child. It has got nothing to do with the court proceedings. It is a personal thing. It's on my heart. And I say again, I have held off until now in order to make sure that when I do try and approach them, that it would be the appropriate thing at the appropriate time. I'm a layman. I don't know how the law works.
Yes, but after you have realized that you can't trust the investigating officer, you approached your
My
lawyer.
lord, I apologize. I've sat and I've listened to this line of cross-examination, but my submission is that it is unfair. The witness stated that she thought it would be inappropriate while the trial was on. My submission is that is actually correct. For the accused family to make contact with the complainant's family would have been inappropriate. There are restorative justice facilities. My lord?
What is your concern?
My lord, to say she should have done it earlier while the trial is on, my
Is there
submission
anything
is...
wrong with it?
My lord?
Is there anything wrong with it?
My lord, my submission is it's unfair. She's the family of the
No, I'm going
accused.
to allow this question.
As the court pleases, my lord.
As the court pleases, my lord. Ma'am, you said you started not to trust the investigating officer.
Correct.
And you went to verify with your lawyer if indeed you can speak to the investigating officer
Correct.
and whether he allowed him to talk to you.
Correct.
Why didn't you do the same to find out from your lawyer if is it appropriate to do that?
I repeat again, ma'am, it is something between me and the parents and that little girl. It is a personal thing, and it's been on my heart since the very minute I heard what had happened to that child. And it's got nothing to do with the public. It's got nothing to do with my grandson's sentencing. It has got to do with what is on my heart. I'm a mother. I'm a grandmother. I have 7 grandchildren. My heart bleeds for that family, for that child.
I agree with you.
I just feel that you're insinuating that I don't care about those people. And that is not the truth.
Ma'am, I agree with you that you say you are a parent and maybe your heart bleeds for that.
It does.
But now, I'm just asking, have you made any attempt to try and reach them?
No.
So that your apology can reach
No.
them as well?
No, I have not. But I have a document on my computer where I talk to the parents, the mother, the child. And I pour my heart out to them.
You have spoken to them?
No, it's a document.
It's a document that
That's
you
correct.
you have it in your computer.
On my computer.
When was this document drafted?
The document wasn't drafted. It was something that has been written over the last 13 months.
And yet you did not make any attempt to try and make sure that it reaches the family.
I say again, when the time is appropriate.
Ma'am, you regard the accused as your own son.
I do.
And you love him so much.
I do.
Yesterday, you indicated to the court that he would protect you, and even at some stage, at some instances, he would even take a blame, even where he is not wrong.
Correct.
And you assisted him to try to rehabilitate from the drug problem that he has.
I did.
Ma'am, and you will do anything to protect him, is that not so?
I will do anything, but I have taken an oath to speak the truth, and I will only speak the truth. I will not fabricate, I will not lie, I will not make up stories. I am here under oath, and yes, I will do anything within my power, and that is within this in the law.
Ma'am, as you earlier said, it breaks your heart to see how the community out there brand him as the Dros rapist, because you know his other side. And you have taken him for rehabilitation about 5 times, is that correct?
That's correct.
And every time he comes out from the rehab center, he will relapse. In those 5 times, is that correct?
Your Honor, may I speak freely?
You are free, ma'am.
Thank you. Nicholas went I just want to tell the court that my grandson never stood a chance. Of the 5 times that he was in an institution, he was at Denmark 3 times, and I said this yesterday. In Denmark, my experience is that it is rife with drugs. The kids are medicated to zombies. And then they go to various work classes every day where they do art things and make bunnies and whatever it is that they do. There is no rehabilitation at Denmark. There is no rehabilitation at Denmark. When he went to Houghton House, he was there for 2 weeks. They begged me to let him stay there for another 3 months at least, and I did not have the finances. My husband had passed away. I have a very small income, and I was unable to keep him at Houghton House. When he went to Healing Wings, he spent an 8-month period there. He came back and he was a different person. For nearly a year, Nicholas was off drugs. Nicholas was doing his matric. He was playing sport. He was at the gym every day. He was clean. He never stood a chance in life. The first 7 years of his life, his formative years, was chaos and abuse and destruction. He came to live with me when he was 8 years old. Between the years of 8 and 12, he was a top sportsman at his school. He's got trophies, he's got medals, he's got so much recognition, academically and for sport. At the age of 12, you have all heard how he was introduced to cat by his mother. That was the end of the road for Nicholas. When he went to Healing Wings and he came out of Healing Wings, my boy was clean for nearly a year until his mother and her partner came to live with me. And she introduced him again to drugs. He never stood a chance. I want to say to this court that unless we get the drugs off the streets, unless we get the drugs out of the prison, our kids will never rehabilitate. There will be murderers, there will be rapists that will sit where Nicholas is sitting for all time, unless we get the drugs off the streets and off the prisons. And I'm calling all parents, all mothers today, to stand with me in the fight in getting the drugs off the prison, out of the prisons and off the streets. We punish these kids, these people that do wrong, and they must be punished. And we say to them, go to jail and go and get rehabilitated. It's not possible. It's not possible because they don't get the support they need. I've been fighting for 13 months to get Nicholas back onto his medication. It still hasn't happened. I have been fighting with the social workers to look into the situation of the drugs. Nothing has happened. I'll phone you back, Mrs. Gericke. We'll investigate. That's all that happens.
I hear you, ma'am, and it's a valid concern for our community, as you say. But now, my question is, he has been to rehabilitation centers, and always when he came back, he relapsed. And now, in some instances, you blame the centers themselves. Is it not true that rehabilitation comes from the heart, from an individual?
Correct.
And because drugs are out there, do you agree with me that if the accused intends to go clean and decide in his own that he wants to go clean, he will, any rehabilitation is a matter of willingness. Is that not so?
It is partly, yes, it is.
And in all those instances, he comes out and he joined his old friends, as it was said in the report, that there are friends that the fiancé did not want him to associate with. Is that not so?
I repeat, Nicholas was clean for almost a year, where he did not mix with those friends, where he studied at home during the day, he went to gym, he played sport, he read self-help books. He was clean for a year. It was only after his downfall on the drugs again, when he used with his mother and her boyfriend, that he began to mix with those people again.
Ma'am, on the issue of him being introduced to drugs by his mother, you say, in fact, you were not present when that happened, is that correct?
I was not present, no.
And you were told by the accused how his mother introduced him, is that not so?
Correct.
And he informed you that it was because on that night, they drank the whole night, and in the early hours of the morning, she introduced him to drugs so that he can sober up.
Correct.
And ma'am, the accused gave another version of how his mother introduced him to drugs. He said he was introduced to drugs when he informed his psychologist, who testified yesterday, that he was introduced to drugs and he accepted the drugs because he wanted his mom to accept him.
I'm sure that
My
was...
Lord, I don't think that the statement is entirely accurate. If my learned colleague can show me, that statement doesn't relate to the introduction, that it relates to continuous use.
Didn't it come out of cross-examination?
I apologize, my Lord.
Didn't it come out of cross-examination? The statement that is now put into the witness.
That was put to the accused as well, and I had to go and check.
He admitted it.
My Lord, no, he said that he used with his mother later on.
The issue of acceptance. He used drugs so that the mother can accept it.
Yeah, but that was the use in general. That was not
What do
the
you mean?
introduction.
Wait. What do you mean when it was used in general? It's evident.
My Lord, the evidence relating to, it's in the probation officer's report.
No. We are not talking about the probation officer. We are talking about the evidence of Mr. Ninow.
My Lord, it was put to him,
Yes.
and he explained it as far as I'm concerned.
What did he say?
My Lord, he said that the first time was that incident that was related. The evidence, and that is what was also said to the probation officer, is that it is because and that paragraph 10.4, I'll read. The accused regards his mother as an older sister. His mother introduced him to drugs, and the accused felt acceptance gekry. So it says the mother introduced him, and another concept of I received acceptance. It doesn't contradict the version that the first incident where it was given to him.
Do you understand the question, Mr. Abe?
Yes, my Lord.
What is the question?
My Lord, the question is, it's suggested that there is a contradiction in that the incident where he was given drugs to sober him up is different from what is in the report. And
The question is, the contradiction stems from the evidence of Mr. Ninow that he used drugs for the mother to accept.
my Lord, I must say I do not agree that is a contradiction. Remember, there are two concepts. The one is the first incident. And then over years he continued using drugs with his mother. And there the acceptance becomes relevant. So it's not to say that the first incident, there's no evidence to say that the first incident was simply to get acceptance. There's no such evidence.
No, I don't think you understand the question. The witness says the mother introduced Mr. Ninow to drugs so that he can sober up, as they were drinking the whole night.
Indeed.
Now Mrs. Goveni says that's contradictory to the evidence of Mr. Ninow, who said that he used drugs for his mother to accept him.
Yes, my Lord, but there's a difference in the context. He also testified about this incident on the first occasion, the very first time. And he said that was to sober him up. That was his evidence.
Oh,
Mr. Ninow.
no,
Yes, my Lord. He testified that.
no.
And after that, he continued, and that is how I
Mr.
understand
Ninow
it.
only said that he was, at the age of 18 years, he was introduced to drugs by his mother.
Yes.
He didn't say he was introduced to drugs after the whole night of drinking.
My Lord, he told the story of his mother picking him and his friend up, and they were with the mother. They drank the whole day, and the next morning when the mother had to take him.
Yeah, let's hear what Mr. Goveni said. Mrs. Goveni.
Ma'am,
What are you saying to the response?
My Lord, my response is, Mr. Ninow, in his evidence, he mentioned that he accepted the drugs so that his mother can accept him. And now, when he told the grandmother, he said, I accepted the drugs because my mom wanted me to sober up after the night, the whole night of drinking.
Lord, if I can reply, his evidence was, he was with his friend, they were drinking, the next morning the mother had to take him home and she gave him the drugs. So there's no contradiction there.
Just leave that for argument. We are going to
I'll
debate
leave
over
it for
that.
argument, my Lord, as the court pleases. Ma'am, you mentioned that the accused grew up and displayed anger
Correct.
in his character, and he was also violent at stage. He was also violent at some stage.
At some stage, yes.
What makes you say that?
When Nicholas came to us, he was going to grade 2 in primary school, and
And at that stage, he was how old?
8 years old.
Was it at the time when you already taken him in?
Yes, when he came into our custody. And he would often get into fights at school. And the school called me in and said that Nicholas has a lot of anger issues. And they gave him counseling, the school psychologist gave him counseling for his anger issues.
And did he fight with other children?
There were fights between the boys, yes.
And except for the report that you got from school, did he display any anger at home?
Towards himself, yes.
And despite that, was he, you say he would protect you. To you, he would be a nice child, obedient, and so on.
Correct.
And the same character he displayed to his fiancée, is that not so?
Correct.
So, ma'am, except for the fights at school, he was never impulsive at home.
Nicholas has an impulsive personality. He's a little boy that will, he was a little boy that will go out there and do it. And this, what I'm telling you now, is probably not good for Nicholas right now. But he is an impulsive personality. He is an outgoing, bubbly person.
When you say he will go out and do it, that will be in your absence. Is that correct?
I don't quite understand. Well,
What do you mean when you say he will go out and do it?
he will, for example, decide, let's get together and go down to the rugby field and see if we can get permission to play rugby on the field. And then they don't get permission. And then they go onto the field in any case and they go and play rugby. That is the kind of impulsivity that I'm talking about.
Is that, do you regard that as impulsive or
Yes.
as
Yes, impulsive.
not
Fine.
taking orders?
He was a boy. He was 8, 9, 10.
Ma'am, here we are dealing with impulsive in the form of, say, anger. When emotions are high, he will do something out of
Yes.
place.
Yes. Yes.
But he never did that in the home surroundings, is
No,
that correct?
he did. He would harm himself. He would sometimes use his fist and slam it into a wall or into a door. Yes, he was impulsive.
So at home, he will do it to a certain limit, is that correct?
Correct.
And if he was out there, you wouldn't know what he will be doing, is that correct?
Correct.
And had he not been arrested on the 22nd of September last year, you wouldn't have known of this incident, is that correct?
It wouldn't have happened if he wasn't arrested.
If he wasn't arrested,
Yes.
you wouldn't have known. If he did it and got away with it, you wouldn't have known.
No, I wouldn't have known.
And you wouldn't have known, as he indicated, that before he went to Dros restaurant, he went to another restaurant, he drank and he left without paying. You wouldn't have known that.
I wouldn't have known.
Yet, ma'am, you come before this court and you say, my Nicholas is not a pedophile.
I think that has been said by the clinical psychologist as well, who's done all the tests available to her.
That was your evidence. Those were your own words yesterday. That my Nicholas is not a pedophile.
Correct. I said that my Nicholas is not a pedophile. And that was backed up by the clinical psychologist who did all the tests available, and her findings were Nicholas does not fit the criteria as a pedophile.
Ma'am, to extend or to qualify what you said, my Nicholas is not a pedophile. The boy that I raised cannot harm a child.
Correct.
And you did not say, you are saying this because of what the psychologists say. You said, because in the context on how you put it, it was based on the fact that you said you raised him.
I did.
Yet out there, when he go and do it, you wouldn't be present. Is that not so?
No parent knows what their children are doing out there. No parent knows.
And yes, I agree with you. And if that is the case, shouldn't parents not come and say things that they wouldn't know out there, that their children are doing out there?
I know Nicholas.
But you don't know him
When he's
out
not
there,
there.
when he's not
Any
home.
mother will tell you sitting here that I know what my child is capable and what my child is not capable of. And I'm telling you that what Nicholas did was an incredibly awful, horrendous mistake. But there was no indication ever in the years that I raised him that he had any pedophilic inclinations. There was never, ever any evidence of that. I never saw it.
Ma'am, I put it to you that you are trying to paint a very good picture of Nicholas at home and outside home. Which is not correct.
I'm trying to have this court see that there is another side to the Dros rapist. He is not just the Dros rapist. He is a human being. He is a person. He's a young man who made a horrific mistake. And I agree, that little girl will suffer. I agree. I understand. My heart breaks for her. But my heart breaks for my son too, because he never stood a chance. From the day he was born, he never stood a chance. Every opportunity that he was given, was broken down.
And do you agree that his conduct as well, his decisions as well,
Yes.
contributed to that?
Absolutely, absolutely. Ma'am, you must remember, a drug addict is an addict for life. To come off drugs is not just a decision you take, like I'm going to cut sugar out of my life. To come off drugs is incredibly difficult, incredibly difficult.
And you need to be firm in what you want to do on your decision, is that not so?
Correct, you do.
And unless you make a decision that I don't want to take this way,
Yes.
you can be sent many times, but you still will come out the same. Is that not so?
Correct.
Ma'am, I put it to you that based on the fact that on previous occasions he was given an opportunity, he never took it to his advantage. And that makes him a danger to the society.
I don't know how many times to say this. The one time that he was given the opportunity, he took it, and he was clean, and he was living a good, healthy life. He matriculated that year. He
And
took
after that he went on again.
And then, yes, and then he fell again. Yes, he did.
And you cannot certainly confirm that should he be given a chance, he will come out clean.
If he's in prison and the drugs is not eradicated from the prisons, he will not come out clean, because it's under his nose. And remember, an addict is an addict for life, and it's under his nose all the time, every day, being offered to him.
As the court pleases, my lord, that will be all.
Any re-examination?
Excuse me, Your Honor, may I just want to say something, if I may?
Is it in relation to this question?
Yes.
Yes.
You've all heard how my daughter made huge mistakes with Nicholas. And I just want to ask that please don't judge her harshly. My daughter has turned her life around. She lives with the guilt of what she did every single day of her life. She is clean from drugs. She holds down a very responsible job. She's raising her child and she lives with me. And I've forgiven her, and Nicholas has forgiven her. And I ask that you don't judge her too harshly. Thank you.
Any re-examination?
Just one aspect. There was evidence that Nicholas at stages displayed anger. How regular would that have been?
It's difficult to say. You know, kids get cross. You tell them you're not having sweets before dinner, they get cross. They get moody. But the actual anger where he would hurt himself is usually when he did something and he knew that he was wrong. His need for acceptance was so great that he would get so angry with himself that he would bang his head against a wall or put his fist through a door.
Was that a regular recurrence? That's my question.
It was regular, yes.
Thank you, Lord. After no further questions.
Yes. Thanks for your time, Amy. I
Thank
excuse
you.
you.
My Lord, that is the evidence for the defense.
Yes. Yes, ma'am.
As the court pleases, my lord, I call my witness, that will be the forensic social worker, Captain Karen Buata.
state your full names and surname for the record.
I'm Karen Buerta.
Do you have any objection to taking the prescribed oath?
No, I don't.
Do you swear that the evidence about to give will be the truth, nothing but the truth? If so, raise up your right hand and say so shall be.
So help me God.
Yes. You may take a seat if you like, ma'am.
I like to stand.
Yes.
As a court, please, my lord. Captain, you are a forensic social worker
Yes, my Lord.
and you're attached to the SAPS, is that correct?
Yes, my Lord.
For record purposes, where are you stationed?
I'm stationed at the Germiston Police Office, but I work for the provincial FCS unit.
And how long have you been there?
Since May 2015.
Since when?
May 2015.
Ma'am, you were requested to compile a victim impact report in this case, is that
Yes,
correct?
my Lord.
And in that report, your CV is also included, is that correct?
A short CV, my Lord.
Can you please read it to the court?
I am a registered social worker for the last 12 years. I am registered at the South African Council for Social Service Profession. I obtained my social work degree in 2007, and in 2011 I obtained my master's degree in forensic social work. I work with vulnerable families and children since 2007. I'm currently employed at the SAPS under the Family Violence, Child Protection and Sexual Offence Unit. Our focus areas are forensic assessments, competency assessments, statements of the children, victim impact reports and statements that are referred by various role players. I further did training on introduction of a child witness, statement taking, forensic report writing, forensic allegations into sexual abuse, and sexual offenders who target children.
Your Lordship, I have a copy of the report. May I hand it in
No objection,
for ease
Mr.
of reference, my lord?
Albert.
My Lord, there's no objection. It would be Exhibit L.
Yes.
As the court pleases, my lord. And now you compiled this report.
Yes, my Lord, I did.
And please remember, ma'am, that in the report you are requested not to mention any names of name of the victim, the family, the school where the victim attends. That should not be disclosed in public.
Noted, my Lord.
Ma'am, can you please proceed reading the report and to the record?
My mandated referral for the report requested was done by applicant S.D. Nkubeni from the DPP offices in Pretoria. I was requested to do a victim impact report regarding the child concerned. My report will focus on various aspects regards to the child concerned and who was a victim of sexual abuse and sexual exploitation. I will skip the CV part, my Lord, because I've done that part. The aim of the report is to assist our High Court in highlighting the impact of the rape with regards to the child concerned. I'm sorry, my Lord, I'm on page 4. Sorry, I skipped a bit.
4.
With the background information, a case of rape, defeating the end of justice and illegal substances was opened with the South African Police Services at Silverton Police Station, and the child concerned was the victim of the first charge in this matter. Nicholas Ninow was found guilty on the charges as above mentioned on the 16th of September 2019. My interview process that I followed was that I conducted one interview with the child concerned at the practice of the clinical psychologist. The practice of the clinical psychologist is a familiar, supportive environment to the child concerned.
And it was
Where are you
the
now?
On page
Page.
4 at the interview process, my
Yes.
lord.
and the child is used to the place where the interview took place. Is that correct?
Yes, my lord. The clinical psychologist is her therapist.
And it is conducive for
Yes.
to accommodate a child.
Yes.
Please proceed.
My date of the interview was on the 2nd of October. I then made use of collateral resources into summarizing my views in this report.
Okay.
As note of the sensitive nature of the particular case, I will also not reveal the identity of the psychologist for the child. The clinical psychologist conducted the office interviews with the child concerned as well as immediate family members. The clinical psychologist offered to conduct these interviews because the family has a trusting and supportive relationships with her and the family members. It was evident that the family members feel more comfortable with the clinical psychologist, and the unassigned social worker respected their views. So there was an interview conducted with the paternal grandparents on the 4th of October 2019, and then there was an interview conducted on the 8th of October with the maternal aunt and the biological mother. The clinical psychologist then provided me notes where I got my information from and summarized it in the report. I then go on to 7.1, the emotional and psychological trauma caused by the crime on the victim. The victim is a spontaneous 8-year little girl. It was evident in her body language that she was extremely anxious, nervous, apprehensive, and spoke softly throughout the interview with undersigned social worker. She stated that she still remembers very well what happened at the Dros restaurant and how she got hurt. She mentioned that she still experienced...
Now, ma'am, I see there in paragraph 7.1.3, you indicate that she stated that she still remembers very well what happened at the Dros restaurant.
Yes, ma'am.
And how she got hurt. And hurt, you've put it in inverted commas.
Inverted commas, because that's
What
how-
does it explain in your report?
The inverted commas is this is her direct words. This is how she explains how she got hurt.
Having gone through the report, I see there are words where now there are words put in inverted commas.
Yes, my lord, there is.
So in all those instances, those were her direct words.
Direct words. I'm sorry, my lord, I should have.
Please proceed, ma'am.
She mentioned that she still experiences nightmares on a regular basis. Her words, the boy, and what the boy did to her. The victim refers to the accused as the boy. Her words, I sometimes still see him. I remember he has brown hair. He had a red t-shirt on, and I think he has brown eyes. I see him sometimes when I have nightmares. She elaborated by indicating that she still has an image of the accused. I see him when I go to bed. I try not to imagine him and what he did to me. I just try to fall asleep. It was clear from the information that I received from the victim that she still has instructive memories of the accused. When asked who she shares her nightmares with, she mentions her words, I don't speak to anyone because I don't want to put stress on my family. My nightmares make me mostly feel afraid and scared. I'm scared he comes into my room like he did in the bathroom. He told me if I tell anyone just one small detail, he would kill me.
Now, ma'am, at that stage when she was verbalizing those words, how were her emotions?
My Lord, she was extremely anxious. It was evident that she's extremely fearful. She spoke softly throughout. You could truly see in her body language that it's a physical emotion for her, that she was fear. You could physically see it.
Please proceed.
7.1.8. According to the victim, she's not afraid of snakes nor crocodiles. But after the incident, she is scared of mostly men at restaurants, which is her words. I'm scared of men at restaurants. I'm scared of restaurant bathrooms. They creep me out. I know now you must go to the bathroom with someone you know. The victim mentioned that she was not creeped out nor scared before the incident occurred, but this has changed for her. Since the incident occurred, the victim only once accompanied her grandfather to an Ocean Basque restaurant. She elaborated on her experiences, stating, I was a little bit scared, but it went well so far. The victim had to make use of the restroom and was extremely scared. It was evident that she developed a fear for people in restaurants, indicating that she's aware you cannot trust people.
So she has lost trust in...
Yes, my Lord, she has.
Please proceed.
She experienced the court proceedings as extremely frightening. She indicated numerous of times she felt unsure with regards to the criminal process. She recalls very well that she had to wear an oversized hoodie to cover her face in order to protect her identity. She recalls the hoodie made her feel scared. She relates that the testifying in court was very scary. She felt extremely afraid and described the court as dark. Her overall experiences of the criminal court proceedings was that it made her feel very scared. Her experiences of the court environment made her words, feel nauseous and felt very, very, very confused. A lot more confused after what happened. The court asked me very confusing questions. It made me just feel confused. The victim is extremely anxious that her identity will be known to the paparazzi, her interpretation of the media involved. She indicated that if her identity will be known, she'll have to be homeschooled and would not have the opportunity to attend a normal school and interact with friends.
In other words, she will not be comfortable to face the world.
She would not be comfortable.
Her name be.
No. The victim explained her understanding of the media involved. She states that the media will film her story, put it on the news. She stated that this will also make her feel very uncomfortable that it would be on the news. The media's involvement was evident that it makes her feel vulnerable and exposed. She indicated her words, I will feel awfully embarrassed. I will then always feel like I cannot go outside. What if they see me because I was on TV and they stop and ask me a lot more questions? The victim stated that the accused threatened her. Her words, the boy said that he would kill me. I still feel that he could kill me when he gets out of jail. Her overall experiences to the rape she experienced and the trauma after the incident made her words, feel angry, scared, upset, and fearful. This is difficult for me and my family. I'm just glad my mom's friend called the police. He practically saved my life. 8 points. The trauma experienced by the immediate family. So there was an interview conducted with the maternal grandparents on the 4th of October. According to the maternal grandparents, the victim was normal before the incident. She mentioned that this has changed. She feels unsafe all the time and needs more attention. They stated the victim
So
was-
the grandparents, does she reside with them?
she does not reside with the grandparents, my lord.
Please proceed.
They stated that she's very emotional after the incident and she cries a lot. The incident also impacted on her academically achievement in accordance with the maternal grandparents.
Do you know if maybe she passed the grade that she was in last year?
She did pass the grade that she was in last year.
And was it the same level that she's been passing, performing at school, or was there any change?
It's the same level, but she did pass, but she was with help.
She did not do as good as she
No, my
normally
lord,
did.
she did not. It impacted on her academics. So. The incident was a big change for them. It was negatively impacted financially, and they are struggling emotionally. The maternal grandparents indicated to the clinical psychologist that we feel helpless and we don't know how to help her. The impact of the incident was affected.
Just before you proceed,
sorry.
the clinical psychologist is a private
psychologist
and of their own choice.
of their own choice.
Please proceed.
The impact of the incident has affected them tremendously. We cry, their words, we cry, it affects us all. We try to keep it secretive and we want to keep it as a family. The maternal grandparent.
Do you know why they want to keep it as a within themselves as a family? Did you
Yeah.
establish that?
My lord, I think the sensitive manner of the case is that there's a label on the family and on the child.
Should the people know?
Yes, my lord. And as stipulated, she has her own identity, and they have their own identity as a family. But the label of the Dros incident, I think that's why they want to keep it as a family.
Proceed, ma'am.
The maternal grandparents stated they feel the matter is private and I should keep it with the close family. It was evident from the information that the victim is also more alert on social media of women and child abuse. She would ask questions to the maternal grandparents, and that will make them feel numb because they don't know how to answer her.
Was it pertaining to this particular case, or what happened
Not
to
to
her?
the particular case, my lord. She's a lot more aware of women and child abuse. So she would ask questions, putting others first. Knowing that she's also in the situation, but she puts others first. She asks a lot more questions now.
Proceed, ma'am.
The maternal grandparents also informed that the night when she had to testify, the previous night before she had to testify, due to the traumatic news, she wet her bed and she was extremely scared. The maternal grandparents were asked, what are their expectations for the outcome of the court proceedings? They stated, their words, we will leave it to the judge. We forgive this boy. We don't know why he did it. For our own sake, we want to heal. We will leave it to the judge. We forgive him for our own wealth. The information
Now,
gathered.
before we proceed on that one, let's go to 8.1.9. You say you were informed that the night before she came to testify in court, she did wet her bed. Did she openly tell them in the morning, or did they have to find out themselves?
They had to find out themselves.
Please proceed.
The interview with the maternal aunt and the biological mother was held on the 8th of October. The maternal aunt states that the incident is an open win for her. We will have to live with this for the rest of our lives. The hurt of not being able to protect a loved one. The biological mother stated that she feels she failed her child. She recalls the incident every day. Her words, "I will never get over this. My trust in humanity is destroyed, and people have lost my trust." The biological mother's biggest fear is that the victim will blame her for not protecting her. The biological mother is fearful that the child will have trust issues in the future. According to the maternal aunt, it was the night before she had to testify. She wet her bed. She was scared, trying to keep it from everyone. When asked what their expectations of the sentencing should be, the biological mother indicated, her words, "Give him life without parole." The maternal aunt stated, her words, "He must get what he deserves. He is a broken person. I cannot waste time and energy to think about him. I must give her a chance to be who she wants to be and needs to be. Our faith is in the justice system. Our faith in the justice system needs to be restored. We need hope for surviving victims. This system is painful." The victim's view on appropriate sentence. I asked the victim, I asked her what her appropriate sentence would be. She stated that the accused needs to be punished and needs to be sentenced to prison for harming her. Her words, "I mostly want him in jail to learn his lesson. He should learn not to harm people and that he needs to be careful." When asked if she would say something to him, she told undersigned social worker that she would inform him of the following. Her words, "He must think of himself and don't allow other people to push him around."
And that is a child of 8 years.
A child
having
of
said
8.
that. Now, you said she was anxious. That is 13 months. When you said you saw her in
The 2nd of October.
2nd of October. That is 13 months after the incident. She was still very anxious.
Yes, my lord, she was.
Please proceed.
At evaluation, I just summarized the report by saying a number of factors impact on the degree of trauma experienced by victims of sexual abuse and physical abuse. This includes the age of the child, the age of the child at the time of the abuse, the duration of the abuse, the extent of the abuse, the identity of the perpetrator, the level of the threats, and the child's mental and emotional health. In terms of the age of the child, the impact of the abuse could be more damaging if it's a younger child. The victim clearly understands her emotional, physical, and psychological pain she experienced. She associates her trauma experience with fear, which will impact on her psychological development in her near future.
Ma'am, in 10.2 you say in terms of the age of the child, the impact of abuse could be more damaging for younger
Children.
for the younger child. What do you mean by that?
Which paragraph is it?
My lord?
Paragraph.
10.2.
My lord, younger children don't understand why they have to get hurt. They don't understand, in this case for the Dros rod, if you go to a bathroom that you have to get raped. So they don't understand. They have no clear understanding. You cannot even reason with them because we as grown-ups also don't know why they have to get hurt. But for younger children, it's more difficult to explain to them. Where an older child, you can have a sense to try to explain to them. Where the impact on the younger children is more severely because they don't understand.
Like in this instance, her
Yes.
age.
Yes, my lord. In her age.
Please proceed.
The accused has left this child with emotional scarring towards, with the impact that he have caused her, that will leave her with a negative self-image and a low self-esteem, which will enhances the victim with vulnerability. When a child experiences a traumatic event, the reaction to the event may become evident a day, a week, or even years after the incident. Therefore, the full impact of the rape has had on the victim may be evident in the years still to come. In the above, it's clear that the victim experienced a traumatic incident and could have long-term emotional side effects, which would include suicidal thought, depression, or self-harming behavior. She was placed in a position where she felt powerless. This resulted in an anxiety, made her feeling vulnerable and unsafe. The rape which the victim was subjected to will not only affect her childhood, but is going to have an impact on her for the rest of her life. The victim is a survivor of rape, but could have ongoing problems with her self-esteem, social interaction, intimacy, trust, personal boundaries. The victim will in all likelihood continue to face emotional, physical, and psychological difficulties continuously in her life as a result of the rape she has experienced. My conclusion and recommendation would be, it is concluded that the victim has suffered physical, emotional, as well as psychological trauma as a result of the rape perpetrated by Nicholas Ninow. The emotional impact and the scarring of the abuse has impacted dramatically on the emotional well-being. This will continue for the rest of her life and the likelihood that she will have ongoing therapy. It is thus recommended that the court take the decisions into consideration when sentencing the accused.
So you mean the court should take into consideration the impact that the offense has had on the accused?
I do, my lord.
Is there anything else that you want to add to your report? That will be all, my lord.
Yes.
Thank you, my lord. I did not have questions.
Yes. Yeah, excuse me.
Oh,
Yes, ma'am.
That is the state's case.
Yes. Mr. Albert.
Short business, my lord. My lord, in short ends of argument, only as far as the case law that I'm referring to is concerned. Obviously, the evidence was still in progress to come. My lord, I accept that the accused will receive a severe sentence. Nothing that I'm saying is intended to detract from that. I'm not talking about 10 years. I'm talking about sentences way in excess of that. So I'm not trying to. The only issue really is whether life imprisonment is the only appropriate sentence, or whether a severe long-term determinate sentence would be appropriate or could be appropriate in the circumstances. And I will mostly rely on the appellant's personal circumstances and his background in order to attempt to sway the court in that regard. My lord, obviously the minimum sentence is life imprisonment. I don't think that requires any further argument. I did refer to the classic case of Velakazi, the test that the court has to apply. Obviously, I accept that the court is well aware of that test.
State versus Villagaz is actually endorsing state versus Malkhas.
Yes, and Dodo, indeed.
Yes, and Dodo as well.
Yes.
And Dodo is a constitutional court decision.
Indeed, my lord.
And both Malkhas and Villagaz cautions the court not to deviate from the prescribed minimum sentence for flimsy reasons.
Indeed, no, I accept that.
Yes.
Accept that. All it says, and I've just used Velakazi because it elaborates a bit more in my mind, where it says all factors need still be taken into
Yes.
consideration, and the mere fact that the sentence or the act falls within that schedule doesn't say that the sentence should always be imposed. But look, then I want to just refer to what the Constitutional Court said as far as life, the consideration of life imprisonment is concerned. That is in versus Dubuza by Justice Ackerman at paragraph 30. As far as the fundamental consideration and procedures regarding sentencing are concerned, our law does not distinguish between heavy and lesser sentences.
Where are you now?
My Lord,
Where are you now?
my Lord, that is on page, the portion I've quoted the
Yeah, paragraph. Which paragraph is it?
paragraph 6. I've quoted the citation, but what I'm reading is not copied into the heads of argument.
Okay.
As far as the fundamental consideration and procedures regarding sentencing are concerned, our law does not distinguish between heavy and lesser sentences. The responsibility resting on the judicial officer may well be more onerous in human terms when considering the choice between the sentence of life imprisonment and the lesser sentence on the one hand than when considering the choice between sentences of 3 or 5 years imprisonment or the choices between custodial and non-custodial sentences. And what the point I'm trying to make is that life imprisonment is a very severe sentence. And the following, this is in the heads of argument, is that it's a quote from the High Court judgment in Dodo. I know that the Supreme Court of Appeal, rather the Constitutional Court, eventually overturned that decision, but my suspicion is that this statement of what life imprisonment entails is still accurate and should stand. My Lord, the sentence of imprisonment for life, irrespective of the policies and procedures to which such sentence may be subjected by the Department of Correctional Services, must be regarded by the court imposing it as having the potential consequence, at the very least, that the accused so sentenced will indeed be incarcerated until his death. It is an extreme sentence. It is the most severe sentence which may lawfully be imposed on an accused such as the one now before court. It is a sentence which in the ordinary course requires a meticulous weighing of all relevant factors before a decision to impose it can be justified. My Lord, and then I go on to refer to State v. Kasi, where they used to describe life imprisonment, that we have used terms like the maximum sentence that is permitted by our law, and to make him pay for it for the remainder of his life. And my Lord, I refer to Zin and Rabi that is tried. I'm not going to take up your Lordship's time in that regard. My Lord, the three pillars of sentencing is obviously the seriousness of the offence, the community's interest, and the accused personal circumstances, which needs to be balanced. And none of that, including the accused personal circumstances, should not be overemphasized, considering all factors. But Lord, as far as the seriousness of the offence is concerned, I can't really say. There's one submission that I can make. As far as the manner in which the crime was convicted or committed, but I have to concede this is an extremely serious offence. And that is a reference to State versus GK, my Lord, and that was a Western Cape High Court decision, but it was cited with approval in State versus De Beer, which is a Supreme Court of Appeal decision, where it was considered that in the past, before the Sexual Offences Act came into operation, certain types of penetration which would previously have been considered indecent assault now falls under the Minimum Sentence Act, and suddenly life imprisonment become applicable. And there is quite a large difference with the sentence that would 10 years ago have been imposed to the sentence now. So that is something that the court must consider in considering whether substantial and compelling circumstances are present. I can say no more as far as the seriousness of the offence is concerned. Then to go on to the community interest. Obviously, the community is justifiably outraged at the commission of this offence. I have to accept. But my submission is that the community's undue weight and elevated above his personal circumstances. I refer to State Justice Flanagan where it says it's not in the community's interest if a sentence is too light or too harsh. The community interest requires sentence to be balanced. I refer to Justice Majid's words in S versus SNM. One cannot only sentence to satisfy public demand for revenge, and also S versus Omerada. It's not the function of the courts slavishly to give effect to public opinion. That was with approval again in the Supreme Court of Appeal in Gardner. My Lord, but this court is.
If you read State Justice Flanagan,
my Lord, I'm not sure. It does have a place. All I'm saying is it should not displace the court's eventual responsibility. My Lord, I refer Your Lordship to, that is the Omerada that says, true justice can only be meted out by one victim or the criminal will never possess either sufficient comprehension of or insight into what is relevant or the objectivity to analyze and recall them as fair sentencing requires. That is why public or private indignation can be no more than one factor, and why a court, like a parentis for the society, is responsible for working out the answer. Now, my Lord, all I'm asking is, as I said, justifiably, the community out there wants life imprisonment. But this court has the responsibility to think back, or not think back, I'll put it this way, my Lord, retribution has anyhow yielded as an aspect, as tended to yield ground to the aspect of prevention and correction. That is no doubt a good thing, but the element of retribution, historically important, is by no means absent from the modern approach. It is not wrong that natural indignation of interested persons or of the community at large should receive some recognition, and the sense not ground is too lenient. The administration of justice may fall into disrepute and injured persons be inclined to take the law into their own hands. Obviously, the latter part of that quotation is not in my interest, but I just quoted the complete portion to be fair. It referred to states that the interest of society is best served where accused persons are reformed. There's also a lot of authority, and I mentioned a few, but the accused should not be sacrificed on the altar of deterrence. And the following statement from Dodo by Justice Ackerman again, specifically in relation to the minimum sentences, I think is quite opposite with the accused today before court with a background and where he came from. Justice Ackerman said human beings are not commodities to which they are treated as ends in themselves, never merely as a means to an end. Where the length of the sentence being imposed because of its general deterrent effect on others being no relation to the gravity of the offence, the offender is being used essentially as a means to another end, and the offender's dignity is assailed. Now, my Lord, life imprisonment is on the cards here, I accept that. All I'm saying why that quotation is apt is that his personal circumstances and where he came from should also require attention in the trial. Then, State versus Kula is an adult decision, but the specific portion was quoted quite extensively, and quite a bigger portion in State versus Kula, but there's only this bit that I want to take away from this. The rest is all relevant, but I cannot conceive of any principle which could justify, for the sake of deterrence, the imposition of sentence grossly in excess of what, in the circumstances of a particular case, and having regard only to the crime and the degree of the particular offender's moral reprehensibility, would be just and fair punishment. The usefulness of, I apologize, that paragraph 19 is a repetition of the previous paragraph. I didn't pick it up when I drafted the ends of argument. My Lord, I need to come to the personal circumstances of the accused, and that is where my main argument will focus. That is where I have the strongest argument. Now, the personal background of the accused, as set out in the probation officer's report, as well as the psychologist's report, my submission must constitute weighty substantial compelling circumstances. It is highly unusual to have a person in accused circumstances where, since he was a baby, he's been knocked around by life, and the parental influence of his mother and the social worker and, well, I could just move this, it's on my notes. My Lord, when you have a mother introducing a child to drugs, now, my submission is the evidence from the accused, and I know my learned colleague disagrees with me on that. He testified, he described the incident, and he said he had to be sober up and the mother gave him the drugs. Yeah. Yes, there is also an element, but I think that is more a general element, that he received acceptance when using drugs. I don't think the two is mutually.
But what I don't understand is the evidence. The evidence is that at the age of 8 years, his grandmother took him away from his mother. Now, at the age of 12 years, he's introduced into drugs by the mother. Where was he staying at that time?
Lord, he was staying with the grandmother, and it appears from all accounts that she had also influence on him. But the mother's influence wasn't totally eliminated, and the damage done up till that time surely just didn't disappear. There's no indication that he received any counseling or anything other than he's now in a loving home, but it's still the same child that had all these problems from mother's time. That would be my submission. And then the mother took him away, and the evidence yesterday was that they were living in previous door. So she took him to a different town away from the mother for the weekend, and then things got out of hand. And he indicated that once he took it once, and my Lord wanted to accept that his bipolar disorder, his drug abuse, has to have some root in his early formative years. And both the experts do go into the factors that would be applicable there. But my submission is addressed on an individual. And my submission would be, we can't just now throw him away. My submission is that long-term imprisonment with the necessary rehabilitation and psychological and reformative components, we should try and fix this individual. I'm not saying for one moment that the drug use excuse these actions. Can never excuse. But if we look at what is said in the State versus Martin, which I think is actually quite a very, I apologize the Lord, I just want to find the correct note here. A very good judgment by Justice Fleming at the time. But I'm just going to take away that one portion. It also talks about remorse later on, which I also will refer to. Where it says to determine sentence, particularly for a more serious crime, there is not a more important question than why did you do it? It's hardly excusable to ask the accused how many children he has and to make the question why did you do it. Only in an exceptional case will the answer to that question not be dominant in getting to understand the influence on the accused and generally to discover the true degree of moral reprehensibility. My Lord, what I'm saying here, drug abuse does not excuse. And your Lordship has pointed out, and that is 100% accurate, that he admitted, and that is still his case, that he was criminally capable. There's no issue of criminal incapacity in the legal sense of the word that he should be found not guilty or should be totally excused. But he did have an influence. And he is also not a person that stood up one morning as an adult responsible and decided to act antisocial or to experiment with drugs for fun or anything. He was really, if one look at that history, he was predisposed to. Mother was an addict, exposed to it since a young age, as a child, exposed, and he needs to be considered on a different footing than another person as far as his drug use is concerned. It's true that he admitted to still using the drugs in prison. My Lord, that is something you could very easily have.
Is it a sign of a person who is capable of rehabilitation?
My Lord, it's not a good sign, I accept that, but my suggestion would be that that per se should not...
Let's interrogate it in this fashion. In his evidence, he says, if he was sober, he couldn't have done what he did on that day.
Yes, my Lord.
Meaning, according to his own version, meaning that drugs and alcohol consumption led him to commit a particular offense. Now he's taken away. He's arrested, he's taken away to prison. Doesn't have bail. In his own version, he says he regrets what he has done. But now he continues to consume the very same substance which made him to commit the offenses. Does it make sense?
My Lord, I do accept that that is a difficult concept.
That's why I'm asking you, is he a candidate for rehabilitation?
What needs to understand is also his version and his evidence that he was absolutely he doesn't see light at the end of the tunnel a lot of days. He's given up on certain days.
Yeah, but but after his arrest and commission of the offense, when he sat down in his corner alone there, he reflected and said, no, if it was not for this drug, I wouldn't have been sitting here. But he continued to continue.
No, I accept that, my Lord. One has to accept also that he's an addict. It's not it's a choice, but it's not a choice in the ordinary sense of the word.
Yeah, but we are talking about a different environment. He's in prison.
And unfortunately, it appears I've had another client who...
where does he get money to buy drugs from?
My Lord, I don't know. I don't know what It's not the first time. It's not totally eradicated inside the prison. That's unfortunate. And that brings me to, my Lord, I want to refer the court to State versus Brophy, but that's not going to be in the context of twice the time incarcerated awaiting trial that they want to use Brophy.
Brophy tells about the conditions in prison.
Yeah, my Lord, exactly.
How long was he incarcerated?
My Lord, 13 months. 13 months. My Lord, but what I want to take away from
Wasn't he arrested last year?
It was last year September, my Lord, 22.
He's now 1 year in custody.
Yeah, my Lord, I'm not trying to rely on.
So it cannot be 30 months.
I'm not trying to rely on Brophy in the sense that of that time awaiting the trial. What I'm trying to say is, as far as the conditions in prison is concerned, there is no rehabilitation there. It says, in my view, there should be no rule of thumb.
Sorry to interrupt you, Mr. Albert. Brophy talks to us about awaiting trial prisoners.
Yes, my Lord.
It doesn't tell us about sentenced prisoners.
Yes, my Lord. But it does state what the difference between the two are. And that is what I want to try and highlight here.
Yes.
The conditions affecting the accused in detention and the reason, what it says is that there is no education and rehabilitation programs for awaiting trial prisoners. So the accused has been sitting there for 13 months, and now I accept what your Lordship is saying, that he should have realized that it's drugs that got him there. But he does not have the same support system in rehabilitation programs that is available once he is sentenced. So it's difficult to predict what difference that would make. And that's really the point I'm trying to make, my Lord. I think Ms. Lamini testified that the accused was drinking very heavily, with lots of shooters and beers and things. And Mr. Ferry testified that he is an old SANAP or Narcotics Bureau police officer, and he could clearly see that the accused was high on drugs. My Lord, the accused acted irrationally.
But when you drafted the Section 112,
My
you
Lord,
accused his statement,
yes.
did you say that alcohol and drug abuse influenced the accused to commit this offense?
My Lord, I'm not supposed to put the mitigating factors into,
No.
it does say he was on the drugs.
No, you said even though he used drugs and alcohol, could still appreciate what he was doing.
Yeah.
So he didn't have influence at all.
In the sense of legal guilt, my Lord, and that is obviously why that is in there, is to say, yes, I'm not trying to hide between criminal incapacity. That is why that is in there. That is the context that is used there.
Yeah.
My Lord, if what, as far as the criminal capacity is concerned, I refer the court to Reiner's case, and my special is when they talk about irrational behavior. And my submission would be, considering what happened on that day at the Dros, that was irrational. I don't think there's anybody here in this courtroom, with the possible exception of the accused, that can understand how that even could have happened. My Lord, he was young. I refer your Lordship to State versus Leenberg, where it says, en dit is in Afrikaans, jeugdigheid is 'n onvolwassenheid, gebrek aan lewenservaring, onbesonnenheid, toestand van vatbaarheid vir beïnvloeding. So it's lack of experience impulsiveness, susceptible for influences.
So are you saying
My Lord,
you are talking about relative?
My Lord, I'm talking about the use of the drug that I will argue had some influence, and I will argue that that just confirms at this young age, and I know what is said in Machichi, but that after quite a paragraph refers to a 27-year-old, that youth isn't per se mitigating factor without exploring the background and developing. I think we've got sufficient information on that for that to go into the equation. My Lord, also, he's a first offender, and I will want to quote from State versus Wood, which I think is also very opposite in this particular case. And I do accept that there's a vast difference in the sentence and the offence considering this as against that the State versus Wood. But I think that the principle is still active, specifically here. The question of an appropriate sentence in the case of a first offender must always present the judicial officer with problems of particular difficulty. The publicity of the trial, the exposure as a criminal, the far-reaching and often devastating effect of imprisonment on his social, family and economic life. In the cases of first offender, aspects of punishment which never should be overlooked. Now, the accused has lost his fiancée, the accused will probably never know his child. Those are all other factors, and the world knows it's a Dros rapist. You will go through life with that stigma. To his own gain, yes, but that is something that is still relevant. My Lord, then if one want to talk, in paragraph 30, I talk about the fact that it's drug intoxication. Intoxication is an important mitigating factor. Breakdown inhibitions, diminish a person's moral blameworthiness, often act in a manner that they would not even consider when they are sober. He said he was acting in a different way, he was acting differently from what he would normally do. Lord, I did find something which is also not a matter of argument. It's a quote from State versus Ndlovu, which might be also just to substantiate my submission that the fact that he was on drugs, although it cannot excuse him, cannot be disregarded, and it could have an influence on his moral blameworthiness. Well, it says it's State versus Ndlovu, it's brackets 2, it's a second Ndlovu case, it's 1965 4 SA 692 Supreme Court of Appeal decision, where it says intoxication is one of humanity's age-old frailties, which may, depending on the circumstances, reduce the moral blameworthiness of a crime and may even evoke a touch of compassion through the perspective understanding that man seeking solace or pleasure in liquor may easily overindulge and thereby do the things which sober he would not do. On the other hand, intoxication may again, depending on the circumstances, prove aggravating circumstances. For example, if he deliberately fortifies himself with liquor. My Lord, the final aspect, and I'm just putting it in the basket. It was only 13 months awaiting trial. For a High Court trial, it's not a particularly long time awaiting trial, but I do refer to State versus Radebe. That is something that needs to go into the basket, although if a court is considering life imprisonment, the impact of that would obviously be lesser. My Lord, then, if we want to look at the accused history of addiction, the first 3 times he went to Denmark for bipolar disorder, it was a relatively short period that didn't have any effect And I think both the accused and his grandmother conceded that he wasn't motivated at the time or he wasn't serious in rehabilitating. Then the Healing Wings episode was for a long period. It's extensive therapy, and he came out and he was clean for a year. Then his mother walks back in his life and he relapses. Outcome House again was a very short time. The grandmother couldn't afford the recommended further 3 months. So my submission is all of this, if one remember, he's an addict. It's not a question, his resolve is limited or is impaired. He's going to spend many years in prison. And if the prison authorities do apply the rehabilitation programs, there must be a prospect that rehabilitation would be, over such a long period, be successful. My Lord, he talks about suicide. I think I touched on this. It seems at times he doesn't see light at the end of the tunnel. He's got no hope. And one can understand that. I think it would be a very exceptional individual that would not be concerned, even if you have remorse and you have true empathy for your victim, that would not also have an element of concern for your own future and own well-being. But it's not necessarily mutually exclusive. Both the social worker and the psychologist is of the view that the remorse are true, and I'll make the submission that what they describe is what is also described in Machiche and also in status.
Yeah, but what does Machiche say with regard to remorse?
The Lord, if I could just...
It says remorse is not about what we say in court. You must look at the surrounding circumstances of this matter. Are you with me, Mr. Albert?
I agree, my Lord. I just want to apologize. As I was talking, I've moved the papers around and...
No, I know what Machiche says. You can argue.
My Lord, it talks about... it's right in front of me. I apologize, my Lord. It talks... since must it talks about that understanding. I apologize, my Lord, I marked too many portions. But it talks about a true appreciation of their own.
Go to paragraph 14 of it.
Yeah,
It will tell you about a genuine remorse.
Now, there it talks about the younger offender. The younger offenders, that relates to background education, etc. It talks about not feeling genuine contrition. It talks about understand, there's a knowing pain of conscience for the plight of another. That's the portion I was looking for. I apologize, my Lord, I was only picking that out.
The circumstance of this case, does it fall within that bracket?
My Lord, I do accept that the accused did not provide a full version.
But Machiche says that for the fact that the accused pleaded guilty, it's not a sign of remorse.
I accept that, my Lord.
Especially in the light of open and shut case, like this one.
My lord, I accept that. I accept that. But what I do pick up from both the social...
And if you can read that paragraph further, it says you must look at all the surrounding circumstances.
Yeah,
Accused appeared in the lower court. Was there any indication that you wanted to plead guilty in the lower court?
my lord, all I can say is that my instructions has always been to plead and what I
No,
understand...
I'm not talking about your instruction because you became involved in the High Court. Talking about the lower court.
My lord, my colleague who dealt with him also advised me that it was going to be a guilty plea.
Yeah, but
that was never...
did he indicate in the lower court that he wants to plead guilty to this?
My lord, that was not the time. He wasn't asked to plead.
Yeah, but you can indicate. You can indicate that no, my client wants to plead guilty.
My lord, I don't think that would really...
That's where this concept of genuine remorse starts.
No, I accept that, my lord.
You can't come to the High Court after 13 months and say, no, I want to plead guilty on the advice. It doesn't come from you, so it's on the advice of a legal representative.
My lord, I don't want to make myself a witness in this case, but...
No, but we have just said it is on the advice. We have just said it, that it was on the advice of a colleague.
No, I said that I was advised by my colleague that it was going to be a guilty plea. So that was never in doubt. But one could possibly stand up in a lower court and say I want to plead guilty, but
Yes.
it would have no
It does
effect.
happen. It does happen. Say, no, my client wants to plead guilty. He was legally represented.
Yeah, but my lord, not before, only before a court that has jurisdiction.
No, state tells you that investigation, everything is finalized. You inform court that no, my client wants to plead guilty.
My lord,
And then the matter is speedily finalized.
my lord, with respect, in practice, in certain offences it could happen, but in the case that was waiting to be transferred to a high court, the accused waited for the matter to be transferred to high court and came to the high court, and the first appearance of the high court pleaded guilty.
Yes.
There can be no doubt.
Even if the plea of guilty is not recorded, but an indication is made to the presiding magistrate that when this matter is ready for trial, my client wants to plead guilty. That I will take it into consideration when dealing with the aspect of remorse.
My lord, I must say I don't agree that that would have been the appropriate time or that would have had any effect.
Yes, and the letters.
My lord, that is the same thing. That letter has been given to me.
Now,
No, some time ago.
when was that?
While I started preparing for the trial during my consultations with the accused. But we must remember, we should not interfere with the state witnesses or potential state witnesses during that
Yeah,
period.
but you can easily facilitate the process through the investigating office or through your colleague.
My lord, that might be so. Then
For example, if you have shot and killed a person, and I feel that I make a great message, I can facilitate through my lawyer or whoever family said no, but I regret for what I've done. And I know there are financial complications for burying the person that I've killed. I can say to my lawyer or my family, say, go and contribute 20,000 towards the funeral.
I think
It's not interference with the state witness.
My lord, it could, in my mind, it could be perceived as interference, and I would not do that.
No, you know you are guilty. You know you are guilty, and you are not buying that family
My lord,
and to say that they forgive whatever you have done.
my lord, I
It
hear
comes out of your heart.
I hear what your lordship is saying, but in my mind, I have to tell your lordship, I would be very, very careful of having any interaction with potential state witnesses.
No, you don't get into direct interaction with them. You can facilitate through the investigating office.
Well, my lord, I stand by my view that I thought it would be improper at the time,
Yes.
and that was my advice.
Yes.
Your lordship would recall that when the complainant testified, when she was finished, I did extend the accused apology to her.
Yes.
That was on his instructions.
Yes.
I did that because that was the only opportunity he would have had to convey that to the complainant.
Yes.
As far as her mother is concerned, the letters and the poem, those are things that goes with the sentencing proceedings in my mind. And what was questions asked of Ms. Gericke earlier regarding going to talk to the family, my lord, there is a process in place for that. And that is the restorative justice system. And that is after sentencing that would ordinarily be facilitated. Would the family know? It's not done through the investigating officer or the prosecutor just asking the family. It's done by social workers and then establishing whether it would be proper and appropriate through consultation with the victims and their family. And that is a process that is still available to Mrs. Gericke, but now is the time when that would be appropriate one.
Yes.
My lord, both the psychologist and the social worker believes that the remorse is genuine, in that he understands the hurt that he caused that film. And I think that comes through in his letter, it comes through in things that they've said, and it comes through in things that he's told them as well. That yes, he does feel sorry for himself. As I said, I think it would be a remarkable human being that would have no feeling of, or no consideration whatsoever for what his fate would be. But he does understand how he harmed that child.
Yes.
And my submission is that is experts that spend time with him, the probation officer, the social worker, and the psychologist that spends time with him. And the psychologist did but mention in her statement that yes, she accepts that he didn't tell everything to this court. She's aware of that. But she still came to the conclusion in her interactions and the psychometric test that she did that his remorse is true. My lord, the probation officer makes recommendation, my lord.
And, you know, of all the witnesses who came here, no one gave a recommendation. The only witness who gave a recommendation is the probation officer.
Yes, my lord.
And it happens to be your client.
My lord, that is a state employee that is tasked with doing this.
And she says to me that I mustn't deviate, I must impose a prescribed minimum sentence, which is life imprisonment.
My lord,
So what must I do with it?
my lord, what we do with that is we have a person who is an expert in one field of the law, who drafted the report, and I will submit that it is in general a very good report. But then
The probation officer's report,
yeah,
including the recommendation.
no, my lord, because then she ventures.
Why do you exclude the recommendation?
My lord, now she ventures onto a field where she's not an expert.
No, but she can make recommendations.
She can make a recommendation.
We see them happening every day.
My lord, yes.
I'm not bound by the recommendation.
No, my lord. But that's
No.
the point I'm making, my lord.
Where are the orderlies?
I accept your lordship is not bound by that, and she did deny that the portions in paragraphs 15.18 and 15.19, where she talks about the community's interest in the precedent that it would set to deviate, informed that opinion of hers. but it's a lay opinion, it's for the court to decide. But those two paragraphs also demonstrate a lack of understanding of what aspects really needs and what value.
No, but you took this aspect, you said, and you said no.
Yeah.
Yeah. So she understood what she was saying.
Yeah. My Lord, but all I'm saying is those two paragraphs, what you said there, it's not legally correct, as I've pointed out to Lordship.
Yeah, but she said they didn't influence her to come to that recommendation.
As a court case, my Lord, then it is only on the seriousness of the offence and nothing else. So I'll leave it at that.
Yes.
My Lord, if I can just go to my notes. She, anyhow, my Lord, just maybe to go back to that for one moment, she did say she believes his remorse is genuine, which I think is important because she was clearly not a partisan witness. My Lord, I would also go on to Ms. Knis and say she's also an objective witness. She's an expert in a field. She goes and she analyzes all the possible risk factors for reoffending. And on many of those points, she makes the determination that, yes, this is a risk factor that remains. And also as far as the drugs and alcohol is concerned, we have the same thing, that she says you will need to go for rehabilitation. Both of them recommends psychological treatment. He's going to need help to reform a lot. But like I said, we can't just now throw him out because he's broken. He's a human being and we need to deal with him. My Lord, she cannot divine the future. I'm talking about Ms. Knis now. She does list risk factors, but at least it doesn't qualify for the formal definition of a paedophile, although she says it's concerning that the child was a victim. And he also, and that the other real negative indicator for rehabilitation would be being a psychopath. And there's none of those two things which would have been particularly negative. Lord, those are my submissions. I don't know if there's anything specific your Lordship would want to hear me on.
Now let's hear Ms. Ngowen.
Thank you, my Lord.
Yes, ma'am.
As the court pleases, my Lord. Your Lordship, it is true that the accused is convicted of very serious offences. In particular, the offence in count 1, rape of a minor below the age of 12, and she was raped
That count
once.
attract life sentence on 2 legs.
That's correct, my Lord.
The complainant was sexually penetrated more than once.
More than once, yes.
The complainant is a child under the age of
12, whereby she cannot consent. Your Lordship, in imposing sentence, the court must look into the factors taken into consideration as expounded in the case of Zin. That is the seriousness of the offense, the personal circumstances of the accused, the interest of society, and the impact that the offense held on the victim herself. Your Lordship, in this case, the accused came before court and he tendered a plea of guilty. And the state, with regard to the plea itself, submits that the plea was not a genuine remorse. He was actually not.
Mr. Albert argues differently. He says you cannot put mitigating circumstances in a plea statement.
Your Lordship, yes, you cannot put mitigating factors, but you will have to take the court into full confidence and give the full account of what happened and take full responsibility of what happened. This is not what the accused did.
But it was
Hence,
rejected.
the state.
The plea was rejected by the state.
That is correct, my lord.
And it
We
was,
rejected
it was
it.
recorded as a plea of not guilty,
That is correct.
except for possession of drugs and defeating the ends of justice.
That is correct, my lord.
So when we are talking about the plea, are you referring to with relation to the count of rape?
Yes, that his initial intention was to purport before this court that, look, I'm pleading guilty. I don't want to waste the court's time. I am coming out clean. Yet he concealed the most important part of his plea. Hence the state says that was not a genuine plea. That is why we did not accept it.
Yes.
And the fact that the accused come before court and say, I am remorseful. Your Lordship, in the case of S versus M 2007-2, SACR
2000, volume 2.
yes, volume 2, page 60 W, the court found that in paragraph 72,
You say it's page 60.
yes, my lord,
At
page
which,
60,
at which page?
my lord,
At which page?
that is page 60 at paragraph 72.
Yes.
The court held that the tendering of a plea of guilty was frequently been taken into account by the sentencing court as a mitigating factor, and that mitigating has been found in the fact that he did not waste the court's time and that it was an expression of remorse. Hence, we submitted that there was no remorse. And in the very same case, in paragraph 73,
But that citation, is it the Supreme Court of Appeal?
that is correct, my lord.
Yes, so it's contradicted by Machich.
Your Lordship?
It's contradicted by Machich, State versus Machich. This is State versus Machich. This is
Your Lordship, that was the beginning of the quotation.
Yes.
Hence, I have moved forward to indicate in paragraph 73, where the same court says, such a plea can indicate a multiple of realities and approaches. Now, it is submitted that the case against the accused was so overwhelming and incontestable that he had to plead guilty, and his plea, the guilty plea that he offered, implied nothing else than that he was being realistic, because he did not have any defense that will suffice to should he have pleaded otherwise. Your Lordship, he was not honest in his plea. Now, Machichi says, a genuine contrition can only come from appreciation and acknowledgement of the extent of one's error. In order for remorse to be valid, the penitence must be sincere and the accused must take the court fully into his confidence. And that the accused did not do. Your Lordship, in S versus Mokhine 2009-2, SACR, page 309, that is the Supreme Court of Appeal Division.
Can you repeat the citation?
S versus Mokhine,
Yes.
2009-2, SACR,
Yes.
page 309, the Supreme Court of Appeal held in paragraph 9 that many accused persons might well regret their conduct, but that does not without translate the genuine remorse. And it is submitted that, Your Lordship, when one considers what the accused gave before this court, it was not remorse at all, and the state was left with no option but to call the victim to rebut his version with regard to the sequence of events. Your Lordship, in paragraph 40 of Machiche,
Yes. 40.
40, yes. The court held, remorse is a galling pain of conscience for the plight of another. Whether the offender is sincerely remorseful and not simply feeling sorry for himself at having or herself at having been caught is a factual question. In order for remorse to be a valid consideration, the penitence must be sincere and the accused must take the court fully into his or her confidence. After all, before a court can find that an accused person is genuinely remorseful, it needs to have a proper application of, inter alia, what has since provoked his or her change of heart, and whether he or she does indeed have a true appreciation of the consequences of his actions. Your Lordship, in this case, as I've mentioned, he did not tell the court that he attacked the child. He actually followed the child into the bathroom.
He says he cannot remember.
Your Lordship?
He says he cannot remember.
Strange enough, he remembers the last aspect of having flushed the panty down the toilet pan. And he remembers most of the happenings on that day, except for those that directly, or except for those which are in direct opposite of his plea of impulsive action. Your Lordship, it is submitted that he planned the offense, and his version of impulsiveness was to move away from the notion that he is fully aware that planned criminality is morally and legally seriously reprehensible. Your Lordship, the accused, despite having been convicted of planned action leading to the rape of the child, he still insists, I did not follow her. She found me in the toilet. I can remember I was sitting down and taking drugs. Your Lordship, that is not an expression of a person who is remorseful. My Lord, in S versus Sejanto, 1998, page 194, CLR, at paragraph 663 and 664.
State versus Sejanto, which year?
1998, Your Lordship.
1998.
My Lord?
Volume?
That is volume 4.
Yes.
The court held that,
Give me the full citation.
Your Lordship, that is the full citation.
No, you can't end up at 4. 1988, volume 4. Is it the SCA or SCR? What is the full
It's a
citation?
criminal law report, Your Lordship.
CRL.
Yes.
Yes. Which page?
Page 663 to 664.
Yes.
The court held that a guilty plea which indicates remorse may also be relevant as a mitigating factor to the extent that it spares the victim the necessity of undergoing the pain or the painful procedure of giving evidence. Your Lordship, we submit that still the conduct of the accused was opposite in this instance. Your Lordship, the accused is not remorseful. That is my submission. The accused only feels sorry that he now has to take full responsibility for his actions, and now that he is facing life imprisonment. In his evidence before court, the accused mentioned that I've been grappling to find words that will express my remorse to the victim. He says, it's been a while that I have decided that I want, or I have written a poem to the victim. But what happened on the day that the victim testified? The only message that was put across to the victim was, the accused says he's sorry. And no mention was ever made that he has composed a poem, or he has a poem for you, which you will later receive, or which will later be displayed to the court, or anyhow. Whereas when the mother testified, nothing was said to the mother, who had broken down so terribly before court, and indicating that what I witnessed on that day, I don't think any mother will want to witness it. Despite the manner in which she broke down, there was no message to say, look, the accused is sorry. His family is sorry. Later on, you will receive a poem or a letter. Nothing of that nature was said. Hence, the state submits that the poem and the letter, those were afterthought, that what can we do to evade long-term imprisonment? What can we do to say, or to make the court believe that I am genuinely sorry? The accused verbalized remorse, but his conduct proves otherwise. Your Lordship, it was also, now I'm moving to the next point, of time spent in custody.
Is it sufficient?
Your Lordship?
Is it sufficient to stand as a compelling and substantial circumstance?
Yes, I will end my argument with the issue of substantial and compelling circumstance. At the moment, Your Lordship, I will take the factors that were raised and factors that should be considered during sentencing proceedings. Your Lordship, the state submits that traditionally time spent in custody while awaiting trial, yes, should be taken into account for purposes of sentence. And then such time should be deducted. Traditionally, yes. But now, looking at the nature of the offense and the penalties that are in place for certain offenses, taking into consideration what kind of investigation needs to be done, that should also not make the court to consider, more in particular, that life imprisonment is an issue regarding the sentence attract.
Did the accused apply for bail in the lower court?
Your Lordship, he tried to apply for bail, but it was withdrawn, and his grandmother also came into play, where she mentioned that it is better if he does not apply for bail because for fear of him being attacked.
Yes.
Your Lordship, now I'm moving to the next point. addiction of drugs or alcohol prior to the commission
I think
of...
it's a strong point of Mr. Albert.
Yes, my lord. Your Lordship, in S versus BP 2011, Volume 1, SACR, page 448, the Supreme Court of Appeal held in paragraph 455, capital D to E, that no substantial or compelling circumstances have to be present, even though it was argued that the use of drugs and alcohol constitute such. In other words, there was a submission that the use of alcohol and drugs should be regarded as substantial and compelling circumstances, but the court found that such cannot constitute substantial and compelling circumstances.
What paragraph is it?
That is 455, paragraph, capital D.
455.
That's correct, my lord. In paragraph E, the court further found that substantial or compelling circumstances will have meant falling into the trap of doing so for flimsy and speculated hypotheses favorable to the offender, as cautioned by in the S versus Malchus. Your Lordship, in S versus Blau, 1999, 2 SACR, page 295, that is a Western Cape decision. At paragraph 303, capital D to H, the court referred to an article written by D. Van Zyl Smith on the topic of mandatory minimum sentences and departures from there in substantial and compelling circumstances. That the article was written in 1999, 15 SAJHR, that is South African Journal on Human Rights. In page 270, the court, it indicated that in South Africa, the voluntary intake of drugs and alcohol is expressly excluded and may not be regarded as being substantial and compelling circumstance. Your Lordship, in response to the fact that alcohol and drug abuse is submitted to be a factor that should constitute substantial and compelling circumstances, Your Lordship, my submission is, in the first place, when one have to consume alcohol, you have to spend money, let alone drugs.
He didn't have money.
Yet he managed to get.
Yes. He wanted to, after consuming, he didn't want to pay. According to him.
Yes, and that is an indicative of how voluntary that can be for one, that he will even cross the line to say, I want to consume, I want to use, even without having, with or without having money.
But it takes courage for a person to enter a restaurant without money and orders
That is so
such
much.
amount of alcohol. And even invite a person he doesn't even know.
And he offered to buy drinks. And at the end of the day, after he has committed an offense, then the court is expected to say it's a mitigatory factor. He was drunk. That should not be the case. Your Lordship, the accused was taken to different rehabilitation centers.
But what are you saying about the broken, upbringing and development of the accused?
Your Lordship, as I've earlier on confronted him, there's a psychologist as well as the grandmother, that in fact, before I come to that, the psychologist said the abuse on a person as a young child can later give different emotions. And in those different emotions, such victims will end up reacting differently. And it depends on which route would one want to lead or to give himself in the route of life. Your Lordship, as much as the accused was introduced...
But this broken life, did it have an impact in him? I'm looking at a clinical psychologist. He said he passed each and every grade without repeating.
Your Lordship?
He passed every grade without repeating a grade.
He passed, he was, that is correct, Your Lordship. And
yeah, but how did it impact on his life?
Your Lordship, in his own words, he says, on instances where I have taken drugs, I would feel much better. That is why I stopped using the medication. And despite him being taken to rehabilitation centers, he still felt, after being released, he still felt that drugs were much better than the medication that has been offered or prescribed to him. And it is difficult to, as much as there was a broken life at an early age, as a growing person, I'll come later at the issue of maturity and in the accused's life. Your Lordship,
are you referring at the time of the commission of the offense?
At the time of the commission of offense, and the fact that he was able, where now he was guided, then he was able to progress in life. He passed grades and he was able to participate in sports and so on. Your Lordship, if the accused accepted and took the opportunities that were offered to him, he could have been a better person. Your Lordship, with regard to the issue of drunkenness, alcohol, as well as drugs.
You have addressed me.
Your Lordship?
You have addressed me on that aspect.
I just want to mention one last aspect regarding that.
Yes.
That if drunken driving is a serious offense, where now road users are seriously condemned from using alcohol or any drugs and later on get into the vehicle and drive, why would it now be regarded as a mitigating factor if a person has taken drugs and has also if a person has taken drugs and also taken alcohol, voluntary taken drugs and alcohol, why should it be regarded as a mitigating factor when it comes to rape of a minor or rape, abuse against women and children?
Sorry, court orderlies, can't you identify these people who are misbehaving and take them out of court? What are the police officers doing here? People are sleeping next to you, you are just looking at them. What are you here for? Proceed.
Your Lordship, we have again in law, Section 1, Sub 1, or Section 1 of the Criminal Law Amendment Act 1 of 1988, where the accused cannot successfully plead drunkenness or that he was under the use of illegal substances. when he committed an offense. If those two are serious and are offenses that should be avoided at all costs, why should they be a mitigating factor in rape of women and children? My Lord, if the accused was intoxicated or if the accused acted impulsively during the commission of that offense, why would he, at the time when he was apprehended in the toilet, make movements to want to ward off the people who were standing at the door? How did he manage to keep the child victim in the toilet cubicle quietly, to an extent that the person, the waitron who was standing on the mirror of the toilet could not hear any movement or hear any child speaking or anything from the inside of the toilet? Let alone, how did he manage to quieten the child when the mother was calling for her? Your Lordship, this is an indication that he clearly planned the offense and was intended to execute it as planned.
What are you saying about the age of the accused?
Your Lordship,
Age of the accused.
I have it in here. Your Lordship, I stand to agree with the decision of Majiji when it comes to the age of the accused, the age that he's young. In the case of Majiji, it was held that youthfulness should not be regarded as a mitigating factor, but aggravating factor, taking in consideration the planning that was held in that case. Also in this case, whereby the accused is convicted of a planned rape.
There's also a matter of DPP KwaZulu-Natal.
No, but that's
versus
correct.
Snow.
Yes, Your
What does
Lordship.
it say?
That is correct.
What does it say?
That in cases where now violent offenses, most of violent offenses are being created, are being perpetrated by young people.
We look at
And that should be taken.
We look at the viciousness in which the manner the offense was committed.
That is correct. So
We
Your
look at the
Lordship.
maturity of the person who committed this offense.
That's correct, Your
Like,
Lordship.
despite the fact that he was 20 years, he was working at that time.
That is correct.
He had a fiancée who was pregnant at that time.
Intending to start a family, Your Lordship.
Yes.
And that is a sign of a person who is matured.
And-
So youthfulness cannot be regarded.
And after committing the offense, he flushed down evidence.
That is
It's
correct.
a sign of maturity.
It's a sign of maturity, Your Lordship.
Yes.
And again, when we compare the age of the accused vis-a-vis the age of the victim,
Yes.
that is a serious
Yes,
aggravating
yes.
factor. Your Lordship, as I've indicated, with the age, the comparison of the age of the accused vis-a-vis the age of the victim, and taking into consideration as well the J88 as compiled by Dr. B.L. Sebupa at Mamelodi Hospital. She indicated in the J88 that the victim weighed 21 kilograms at the time of the offense, and the height was 128 centimeter in height, and the body build small. Your Lordship, the J88 further described that the breast development was on 10 stage 1 and the pubic hair at tenor stage 1. She's small, very little, tiny, little girl. To an extent that the accused, at mere looking at her, would see that this is not an adolescent girl or a girl who is about to mature, but a very little child. Yet that is why he preyed on her and attacked her. Your Lordship, we've already passed that he was living with his fiancée and preparing to start a family, where now at the moment as we speak, the child, a boy, has been born. Your Lordship, in Machichi, paragraph 14, says a person of 20 years or more must show by acceptable evidence that he was immature to such an extent that immaturity can operate as a mitigating factor. In this case, he was matured that that cannot be regarded as a mitigating factor or substantial and compelling circumstance. Your Lordship, in another case, S versus Patrick Vusimuzi-Ngobo, that is case number 1344 of 2016, it is an unreported case held on the 6th of February 2016 by the Supreme Court of Appeal. The court held that, relying on Majiji and Malhas, that even if there were factors indicating that the accused was immature to such an extent, his maturity must not be taken as substantial and compelling circumstance. Your Lordship, when we come looking into the impact before I come to the impact, my Lord, may I canvass the issue of the nature of the offense itself. In S versus Chapman, the court held that rape is a very serious offense, constituting as it does a humiliating, degrading, and brutal invasion of privacy, the dignity and the person of the victim. Your Lordship, it's humiliating that where a child was attacked, raped by an adult in a public toilet, putting his penis into her mouth, penetrating her vagina with a finger, and thereafter, as if that was not enough, he takes his panty, her panty, and all the underwear. Your Lordship, the child, in her own words, says, I'm scared if they know that I am the one who was violated. People will ask questions. I'm scared if at school it will be known that I'm the one that was raped. I'll have to leave school and be homeschooled. Your Lordship, that is the extent of impact that the offense held on this child. Your Lordship, it is also described in S versus, rape is also described in S versus Swartz as a cancer in our society. Your Lordship, looking into the proportion in which rape, woman and child abuse is happening in our country, is quite alarming and needs to be harshly stopped. The statistic relating to such crime against children is a cause for concern, Your Lordship. One stands to wonder, what kind of a nation are we raising when children are being subjected to such abuse? Your Lordship, the statistics has drastically increased. During the previous, the recent Child Protection Week, the statistic released in Parliament showed that cases of gender violence in 2018, in cases of gender violence in 2018, 41% of the reported cases involved children. Your Lordship, also on the statistic that was released by the SAPS 2018-2019, sexual offenses is in the rise by 9.6%, attempted sexual offenses by 3.9%, and contact sexual offenses by 2.7%. Hence, I submit that such conduct needs to be harshly stopped. Your Lordship, in 2018, it has been reported that 2,600 children were murdered, tens of thousands of babies were abandoned, of which 2 out of 3 were reported to be dead. It was further reported that 99% of children have witnessed violence. As a result of the statistics, the humanitarian organization, World Vision has recommended that violence against children should be treated as a national disaster. Your Lordship, in Machichi, rape was described as a pandemic that engulfs our society, and it has not abated. Thus, the court are duty-bound to implement the sentences prescribed in terms of the Act. And that ill-defined concept, such as youthfulness, alcohol, I add, or other equally vague and ill-founded hypotheses that appear to fit the particular sentencing officer's personal note of fairness ought to be eschewed. Your Lordship, not only the victim suffered as a result of this offense, the family as well. They feel helpless that they can't help the trauma that the child is suffering. She still has nightmares. They can't do anything about that. The trauma is deeply embedded in her thoughts to an extent that it is there forever. Your Lordship, this crime had a very serious impact on the child, as I've earlier on referred to the J88. On the gynecological examination, that is paragraph E of the J88, shows that the paragraph 6 indicates that the urethral orifice was swollen and bruised. Paragraph 7 says the paraurethral folds were swollen and bruised. Paragraph 9 says there was a fresh laceration of plus or minus 3.5 millimeter on both inner labia minora. Your Lordship, the extent of trauma suffered by both the victim are very serious. Now, on my last point, last but one, the court should also take into consideration the interest of the community.
How is the interest of the community best served by the court?
Your Lordship?
How is the interest of the community best served by the court?
I'll submit that
Have you read State versus Mtlagas?
I think vaguely I can remember that.
What does it say?
Your Lordship, vaguely from the top of my head, that the interest of the community is best served more on, that's my emphasis on my own words,
Just leave it at
as the court pleases. I'll leave it to that, but
Yeah.
my submission will be
yes.
the interest of justice or the administration of justice is mostly or seriously adhered when sentence is imposed. That is, the community is more interested in to see if this kind of offenses are being perpetrated. What does our court say? The extent in which women and children are being attacked, violated, they look up into our courts for solution. Hence, it is my submission that the court should not easily deviate from imposing minimum prescribed sentences, because now such kinds, they are serious and they cause shock and outrage to the community. Your Lordship, in the case of, it's an unreported case which was held in this court of Jomo Molefe Serage, that is case number A, that was an appeal court, a full bench decision. The court held that rape is rife and prevalent across the country. Our courts are obliged to render a service to the community in endeavoring to send a warning to any prospective criminal to refrain from harassing and terrorizing women and children. In the case of S versus Swart, the court emphasized the seriousness of the crime and that such crimes that attract retribution and deterrence, rehabilitation will play a smaller role. Your Lordship, as much as the court should not be out there to satisfy the public opinion, I think that was held in Mhlakaza.
Yes. That's what I wanted you to say.
Yes. As much as it's not the duty of the court is not to satisfy the public opinion.
If you say public opinion, it's a flawed thing for the
it's a flaw.
Yes.
That is correct.
Yes.
But the community or the public must be served. They must have my submission. The public should have confidence in the justice system. And the public should know that the courts are there.
Are you saying the confidence is eroded?
Your Lordship, if lenient sentences are imposed
For serious offenses?
for serious offenses, the community will tend to take the law into their hands, and the administration of justice will come into disrepute. And that should not happen. Your Lordship, in a fight or try to condemn, publicly condemn that acts of violence against women and children, the community has mobilized. They've come out with different kinds of organizations just to make perpetrators that we are aware this must come to a stop. And surely, Your Lordship, the community must also be heard. The President also mentioned that it was as a result of these offenses being on the rise that offenders should be harshly punished. Your Lordship, it is my submission that it should happen and it should start. If it hasn't started, it should start now and here. That is my submission, Your Lordship. At the beginning of my argument, I indicated to the court, that is a given factor, that the offense in count 1 attracts life imprisonment unless there are weighty justifications that will cause the court to deviate from the minimum prescribed sentences. Your Lordship, the
Possession of drugs? Possession of drugs?
not possession of drugs, Your Lordship.
I'm asking you. What sentence is it for possession of drugs?
Your Lordship, on the possession of drugs also, it should be
Is there a prescribed sentence?
no, but I've mentioned that in count 1, that count 1 calls for minimum prescribed sentence.
Yes.
That's correct. Now I'm arguing on substantial and compelling circumstances.
No, yeah, you'll come there. I just want to know. Possession of drugs?
Depending on
What
the
are you
amount
looking at?
of drugs, there is a penal.
What are you looking at?
We're looking at 5 years or more.
Yes, and defeating the end of justice?
Depending on
Don't say
the,
depending. What are you looking at?
I'm looking at 5
Yes. Yes, go to substantial and compelling circumstances.
as the court pleases, my lord. Your Lordship, substantial and compelling circumstances is not defined by the legislature,
Yes,
and it has been left to the courts
yes.
to weigh, to assess, and come to a conclusion whether there are substantial and compelling circumstances. Your Lordship, before court here is a rape of a 7-year-old, whereby the legislature calls for life imprisonment, and for the fact that a child of 12 years, 7 years, cannot consent to sexual intercourse. Now, my big question is, what can be substantial or compelling to cause the court to deviate from a person who perpetrated an offense to a 7-year-old who cannot consent to sexual intercourse, who cannot enter into any legal contract? A child of 7 years needs protection, and a child of 7 years cannot speak for herself. What can be there that can weigh heavier than rape of a 7-year-old? My response will be absolutely nothing can weigh heavier than that. there is nothing that can be weighed proportional to the trauma that she suffers. There's nothing that can be proportional to cause the court to deviate from an unlawful, intentional, and planned rape of a 7-year-old. Your Lordship, in the case of Majiji, the court further held that in paragraph 20, that our constitution order can hardly survive if court fail to properly patrol the boundaries of their own power by showing due deference to the legitimate domains of power of other arms of state. The court further held in the same case that Parliament have spoken. It has ordained a minimum prescribed sentences for certain specified offenses, and courts are obliged to impose those sentences. Your Lordship, it has been argued on behalf of the accused that the nature of offense, although it has been classified as a rape in the current law, it was previously regarded as indecent assault. The question is, the trauma suffered.
Yeah, but it's no longer argument because rape is clearly defined in the sexual.
It is that is correct. I mean,
why are you raising it now?
The reason I'm raising it, it is argued that it should be viewed in a lighter sentence.
Who said so?
That was the argument submitted before this court, my lord.
I didn't hear that argument.
It was submitted.
Did you say that, Mr. Albert?
Lord, I did refer to SC Supreme Court of Appeal Authority that said
No, did you say that?
My Lord?
Did you say that I must look at it differently?
My Lord, the authority is that...
Did you say that? What is difficult to say yes or no?
Yes, my Lord.
Yes, no, fine. I didn't hear that argument.
As the court pleases, my lord.
Yes.
The fact that it is now included as rape, it is rape.
Yes.
The trauma that will be suffered is not different from if a penis was directly penetrated into.
Yes.
Your Lordship, in Majiji, the court further held that predictable outcome, not outcome based on the whim of individual judicial officer, is foundational to the rule of law, which lies in the heart of our constitutional order. Your Lordship, in the case of Christian Education South Africa versus Minister of Education, the Constitutional Court held that under Section 7 sub 2, the state is obliged to respect, protect, promote, and fulfill the rights enshrined in the Bill of Rights. Here we have Section 28 that says the rights of a child are paramount. My submission is that there's nothing that can outweigh the paramountcy that is entrenched in the Constitution regarding the rights of children. Maybe one should ask, what is child protection? The Save the Child Foundation defines child protection as measures and structures to prevent and respond to abuse, neglect, exploitation, and violence against children, whereas the ordinary meaning refers to child protection as safeguarding the children from harm. In order to safeguard or protect the children, especially children 12 years and below, children who cannot consent to sexual intercourse, then there must be full protection. Looking into the fact that there are measures in place when now a child 12 years and below has been offered protection to say such child should not come before court, should not testify in an open court. That is protection. The very same child who has been violated, after conviction, now the court says, we have heard you, we have protected you. Now let's hear if we can find substantial and compelling circumstances to deviate from...
Is it for the court to find it?
Your Lordship?
Is it for the court to find it?
Your Lordship?
No, the honors lies with the accused.
That is correct.
So it's not for the court to
my
find
submission is that should a person be convicted of rape of a child 12 years and below, the fact that such a child cannot consent, it should not, the court should not even try to call the accused to say, prove if there are substantial and compelling circumstances. Such perpetrators should know that rape of a child 12 years and below, they do it in their own peril. I know there will be...
So your arguments call for the amendment?
As the court pleases.
Because it's not me. It's the act which says that.
Your Lordship...
I don't understand your argument.
It is true. Your Lordship, the court is called to uphold the Constitution.
Yes.
And where now?
And the rule of law.
And the rule of law.
And then what does the rule of law say?
Where now?
The rule of law says that where they are compelling and substantial circumstances, some must deviate. The onus is on the accused to prove that.
That is correct.
Yes. Now your argument suggests otherwise. It means there must be an amendment of the act.
If the court
Because
deems it fit,
what you are arguing
it is my
against,
submission
what
that
you are arguing, I guess, is embodied in the act. It's there in the act. And it's constitutional. It passed the constitutional muster. This matter was to the constitutional court.
as the court pleases, Your Lordship, I will leave it to
Yes.
that. And then it is my final submission that all factors taken together in this case indicates that there are no substantial and compelling circumstances
Yes.
that will make this court to deviate from the minimum prescribed sentence of life imprisonment. And the state prays for life imprisonment as the court pleases.
As a court please, my Lord, very briefly, just a quick comment on my Lord, my submission is that apart from what we see and what, because the argument is that there is no remorse from what my learned colleague observes. The experts who look into his personality is of the view that there is true remorse. My Lord, the question was asked, why was the poem not read to the complainant when she testified? I did choose to convey in words. I think the poem would have confused her with respect. And also these are decisions made by me. The suggestions the letter was only written now on with no factual basis to make that submission. There are processes in the court, and I followed those for when mitigation is done, etc. Then the case of S versus BP, I accept in that case there was no substantial and compelling circumstances, but obviously every case has to be considered on its own merit. And if this SWAT case is the same case I'm thinking of, just for interest sake, then the court did deviate from the minimum sentence. Yes. Those are my submissions, unless there's anything else, my Lord.
Yes. I'm now going to consider what you have submitted. I'll come back at 2 o'clock. If I get delayed, you must be patient with me.
As a court, please.
Yes.
It's a good business.
Court agents.